This is The Legal Exchange with Todd Lutsky from the law firm of Cushing & Dolan and Susan Powers of the Armstrong Advisory Group. Each week, Todd and Susan will discuss many topics, including estate planning, how to avoid probate, and protecting your money from a nursing home. If you need assistance in any of these areas or have a question about another issue that may affect your future, call 866-848-5699 to make an appointment. That's 866-848-5699. Operators are standing by. Now, here are your hosts, Todd Lutsky and Susan Powers.
Welcome into the Legal Exchange with Todd Lutsky. I'm Susan Powers, a financial advisor with the Armstrong Advisory Group, and I'm joined by Todd Lutsky, a partner with the law firm of Cushing & Dolan with a master's in taxation. Welcome, Todd. How are you today?
I am never better. And you?
I am great, thank you. What do you have for us this week?
A couple of interesting cases. A D.C. appellate court case, and then we're going to head over to Nevada and do an appellate court case there. This one is joint accounts, probate or not. An interesting situation because the estate of Bertie Fulton had closed, but the kids had a disagreement. And then one of the kids said, well, wait a minute. They're going to reopen the estate, and said there were two accounts that were open back in 96 and 2012 that I was listed as joint owner on, and therefore I get those. That was $470,000, and those are not part of the probate estate. Well, we're going to find out that they might be, and we're going to talk about what probate, when something is a probate asset and when it's not, and why it makes a difference, and of course, how to fix it. Then we're going to go to Nevada, and there's an appellate court case there where it says, when is a trust really funded? In this instance, prior to death, David set up a revocable trust disinheriting all his children. However, the document itself referenced the funding of the trust by saying, hey, take a look at Schedule A. Whatever's on Schedule A is in the trust. Well, there certainly was a property listed on Schedule A, at least the value, but not the address. And now, no deed. Question is that property in the trust or not? And so we're going to learn about the statute of frauds, and we're going to learn all about funding a trust and the problems if you don't fund them. Well, that said, folks, today we are at the end of the month, and this is our last chance ever to get this guide for this month. And this is one that deals with, look at these cases, right? They're planning done incompletely, and you find yourself in a situation like maybe facing a nursing home, and you may or may not have done your planning. If you have, you might have assets still outside the trust that are at risk. If you haven't, you might be faced with writing a check to a nursing home, looking at the plan saying nothing got into a trust, nothing was funded. What do I do? Get this guide, Long-Term Care Planning for Procrastinators. It will help you if you're faced with nursing home care to learn what's a countable asset, what's not a countable asset, how a home can be a non-countable asset, how you can convert a rental property to a non-countable asset. Folks, don't just write the check. Get the guide, 866-848-5699, and learn how to protect your assets last minute from the nursing home. Or go to our website, legalexchangeshow.com, and you can download it there. Again, 866-848-5699 or legalexchangeshow.com. So, Susan, we're going to go learn about joint property.
I'm very curious on this.
Interesting. So we set the table. We got the estate of Bertie who had this trust created and basically disinherited the kids. But they opened it up and said, wait a minute, there's $470,000 of joint accounts in this one daughter's name. So I should get that. And the D.C., this is a District of Columbia case, says that what you do is you look to the bank. The bank has contracts, and whatever the bank's contract says is what governs here, okay? And joint with right of survivorship means that if one joint owner dies, the other joint owner gets it automatically.
Sure.
And outside of probate. That's what it means. Okay, well, they went looking through the bank records to see if there was any contracts, and all they could find was a signature card that basically provided no evidence or indication as to whether or not it was joint with right of survivorship or not. And so, and no terms and conditions were listed there. So now we don't have any guidance. So according to the D.C. joint rule, it looks like it's not joint with right of survivorship.
So would it be more joint with tenants in common?
Well, let's keep going.
Yeah.
Well, it turns out in 2013, the bank put together a manual that says the presumption is, unless the account states otherwise, it will be joint with right of survivorship.
Okay.
Okay, well, the probate court said, okay, we're going to follow the manual, and we're going to say, Nadine, you win. These are joint assets, and you get them. Well, the other kids weren't too happy about losing $470,000, so they appealed. And the appellate court reversed.
Really?
The appellate court reversed, saying, well, wait a minute, the 2013 manual didn't exist in 1996 or 2012 when these two accounts were set up. So therefore, they should not be governed by those.
That makes sense.
By that 2013 manual. And since there is no evidence to the contrary, these are probate assets. Nadine, you lose.
Huh.
And
the whole thing, not just half.
You don't lose the whole thing. You lose the fact that you're going to get it all.
Right.
It's now going to be a probate asset, and they're going to turn to the probate court and say, is there a will? Does the will say equally to the kids? Or is there, even if there's not a will, is there intestate succession statute that says who gets it?
Right.
So it doesn't mean that Nadine's going to get nothing. It more likely means that the whole family's going to share probably equally.
Right.
Unless the will disinherits Nadine, which I don't have any facts to that.
You left us with a hanging case again, didn't you?
No, this is really a great case, and I think it's important.
I like the drama. Could you please include the drama next time?
I think it's an interesting fact pattern, right? And so let's just spend a minute learning a little bit what we can take away from this. So joint with right of survivorship does mean that whoever the surviving joint owner is gets the asset. Okay, well, what are the pitfalls of that? Well, you could disinherit a child, which is what they were going for here. Nadine was saying, hey, this is mine.
Right.
You don't get any because I'm joint. And if it truly was joint with right of survivorship, Nadine probably would have won. And she would have get it. So you got to be careful that you might be naming your children as, joint owners on your account because that one child is geographically close to you.
And it's a convenience.
Very convenient.
Right? Yeah.
Write a check, pay a bill. Susan, you get that all the time. So they could pay a bill or whatever. But you don't mean to disinherit the other children.
Right. That's not your intention.
But that's what could happen. So be careful there, folks. Safer approach, use a power of attorney. That way you're not listing the kid as a joint owner. You're just giving the kid power to access the account while you're alive.
Right.
Not when you die. It's while you're alive. Now, Cushing and Dolan actually drafts their wills with specific language in it to prevent accidental disinheritance. We have language that says, we understand that there may be joint accounts that were set up for convenience reasons only. We want them to go to probate and not avoid probate and be treated as a joint account. That way we prevent accidental disinheritance of people, because that language will then govern the will. And then if it's a pour over will, it'll then take the asset and throw it in a trust, and the trust will give it whatever the donor's intent was in the trust. If it's equally to the kids, then it will go equally to the kids. So I think that's important to understand, and that's why we do that language. What about from a Medicaid situation? What does a joint account mean there?
Right.
Well, when you have joint accounts from a Medicaid perspective, it's deemed 100% available. So don't think that because you put a joint name on a bank account that somehow half of that is protected. It is not. It's deemed 100% at risk unless you can prove contribution by the other party, right? And also from a step up in basis standpoint, it's completely the opposite. If you have a joint account with a non-spouse and you die, it's deemed 100% includable in the decedent's estate unless you can show contribution.
Right.
So you could get a full step up. But folks, really, all of this to me is what happens when people procrastinate. Right? That's really what it's about. If you don't put your ducks in a row, you're going to be faced with these kinds of, dilemmas, these kinds of problems. It could come from a Medicaid standpoint. It could come from accidentally disinheriting a spouse standpoint. And again, from a Medicaid standpoint, if you didn't, put your ducks in a row and you find yourself faced with a nursing home situation, please don't just write the check, folks. Call and get this guide, Long-Term Care Planning for Procrastinators. It will help you understand what's countable, what's non-countable, and how you can make things that, quite frankly, might be countable, non-countable. And then you can maybe get yourself eligible for Medicaid. 866-848-5699 or legalexchangeshow.com.
Folks, you've been listening to Todd Lutsky, a partner with the law firm of Cushing and Dolan. I'm Susan Powers, a financial advisor with the Armstrong Advisory Group. We've got much more to come when we return on The Legal Exchange with Todd Lutsky.
You've worked hard to achieve wealth and prosperity. Don't let an unexpected nursing home stay take it all away. According to Genworth, the average monthly cost for a private room in New England could increase by up to 25% by 2030. If you or a loved one might need nursing home care in the near future, and you're not prepared to handle these kinds of costs, you need to call the experts at Cushing and Dolan and get their new guide called Long-Term Care Planning for Procrastinators. In it, you'll learn strategies that can help you protect your assets that you've worked a lifetime to attain. Don't put off today what you might really need to do tomorrow. Call Cushing and Dolan right now at 866-848-5699 and get your free guide called Long-Term Care Planning for Procrastinators. That's 866-848-5699. Or you can request it online by visiting legalexchangeshow.com. The proceeding was paid for and the views expressed are solely those of Cushing and Dolan. Cushing and Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing and Armstrong do not endorse each other and are not affiliated.
Veterans benefits just got a whole lot better. Whether you're about to leave the service or you've been out for decades, the PACT Act gives eligibility for VA benefits to thousands of veterans. The PACT Act is a new law that expands benefits for veterans exposed to burn pits, Agent Orange, and other toxic substances. To learn more, visit va.gov/PACT or call 1-800-MY-VA-411. If you or a loved one served this country, it's time to get the benefits you deserve.
An extended nursing home stay could deplete your savings in months if you're not prepared. Learn about the steps you need to take to protect yourself, your family, and your assets from these high costs. Get Cushing and Dolan's new guide called Long-Term Care Planning for Procrastinators. Call 866-848-5699. That's 866-848-5699. Or you can request the guide online by visiting legalexchangeshow.com. The proceeding was paid for and the views expressed are solely those of Cushing and Dolan. Cushing and Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing and Dolan and Armstrong Advisory do not endorse each other and are not affiliated.
For 40 years, Cancer Support Community has been a relentless ally for anyone impacted by cancer, with free services provided online and in person, with their newest location in Massachusetts. Connect with Cancer Support Community Massachusetts for free emotional support, educational resources, patient navigation, financial counseling, and more. 617-797-3391. CancerSupportMass.org. CancerSupportMass.org.
The United States Virgin Islands are St. Croix, St. Thomas, and St. John, and they are the perfect place for your next vacation. From the moment you arrive, you'll find yourself falling naturally in rhythm with the heartbeat of the islands. Because with perfect weather and year-round temperatures of 75 degrees, relaxation is at its finest. Enjoy their spectacular beaches, world-famous cuisine, golf, tennis, and a wide variety of water sports. The U.S. Virgin Islands is one of the most popular vacation spots in the Caribbean. So head to visitusvi.com and explore their wide variety of travel packages today. There's no money to exchange, no passport required, and best of all, no more domestic travel restrictions to enter. Paradise awaits you. Go to visitusvi.com for more information and to book your trip today. Come to America's Caribbean paradise. Visit usvi.com. That's visitusvi.com. You're listening to The Legal Exchange with Todd Lutsky, an expert in elder life planning and taxation. Need help with your estate plan? Call Todd right now and make an appointment. 866-848-5699. That's 866-848-5699.
Welcome back into the Legal Exchange with Todd Lutsky. I'm Susan Powers, a financial advisor at the Armstrong Advisory Group, and I'm joined by Todd Lutsky, a partner with the law firm of Cushing & Dolan with a master's in taxation. Welcome back, Todd. What do you have for our second story?
Well, it's a Nevada appellate court case, and I'm going to title it, When is a Trust Considered Funded? Well, let's take a peek. So, prior to death, David sets up a revocable trust, disinheriting all his children. Okay? And the trust has language in it that references funding the trust, and it says it's funded with assets listed on Schedule A. Wow. Well, we have a Schedule A, folks, and I can tell you our trusts aren't funded based on what's on Schedule A. Schedule A, in my mind, is a little convenience thing.
The $10 thing, right?
Well, it's convenience. If the client wants to list what's in the trust to remind them what they put in,
got it.
You can put it there. I don't believe that it actually puts it in the trust, but it does say in this particular document that we're referencing Schedule A as items that are to be in the trust. Mm-hmm. Okay, well, that's what the trust says.
Everyone can have a dream.
Well, David died, and the sister, because the children are disinherited, the sister says, I'm sole trustee and sole beneficiary of the trust, and I'm going to petition the court to take over the home. Well, the children didn't like that fact that they're disinherited, so they objected, and they said, hey, the property's not in the trust. There is no deed ever prepared transferring the property from Dad's name to the trust. So if you go to the registry and you look, the deed is still in Dad's name.
Right.
It's not in the trust. Well, there's the appellate court took a look at the statute of frauds. Now, folks, the statute of frauds says that in order to deal with real estate or transfer real estate, you need a written contract. You can't have these oral things that says, Susan, I'm going to transfer my house to you.
He said so.
Yeah. I can't do an oral contract. You got to have a writing in order to effectuate a transfer of real estate. That's what the statute of fraud says, some kind of a written contract. However, the court, in this case, took a more realistic interpretation of this statute of frauds and said, well, let's consider the intent of the settlor. Mm-hmm. Again, intent is very important when you're drafting documents. Well, in this case, they said there is a writing that sufficiently describes the property and the intended conveyance. So we should allow the transfer to the trust, because of this. In other words, they looked at the Schedule A. Schedule A didn't have the property address listed, but it did seem to indicate the value, did say that it was his home, and that was the only property he owned on the date of his death, and the value was close to that value. So clearly that's what he meant to do. And it is a writing, so it doesn't have to be a contract, but that's a writing, and we're going to say that that satisfied the statute of frauds. And therefore, this trust is funded even though I don't think it was funded.
Wow, because if he ended up in a nursing home and that was an irrevocable trust, they would not view that as funded.
It's a very good analogy.
Yeah.
And I think we're going to definitely explore this a little bit and find out what the lessons are we can learn from this. But you're right. If you went into a nursing home, I would not bet that the state would say, yeah, this is funded. They're going to say, give me your house.
I'm no attorney, but I've listened to a couple of things you've said in the past 15 years, so that's just my layperson's opinion. And on that score, that is exactly the guide we're giving away, folks. It is the last chance. It's the end of the month, so please call and get the guide if you'd like to get it. And it talks about stuff like this. If they had not funded the trust properly, even if you've done your planning, you might find that you're still at risk for the nursing home. So how can you save this house last minute, in this case, if it was not actually transferred to the trust, or save your rental property, or save your investment portfolio? There are techniques to do that, and you can call and learn how to do that last minute by getting this guide, Long-Term Care Planning for Procrastinators, 866-848-5699, or legalexchangeshow.com. Again, last chance, folks. It's the end of the month, 866-848-5699,
or legalexchangeshow.com. Now, lessons.
Yeah.
What do we learn from this? We learned that this person was very lucky. They went with the donor's intent, and they said, you're lucky that this was in the trust, because I think the lesson I learned from this is don't rely on this case. Mm-hmm. Make sure you actually transfer the property into the trust via a deed. Okay? This situation, they got lucky. They looked at the donor's intent. They looked at Schedule A, and they said, fine, kids, you lose.
And he had disinherited his kids, right? So when you specifically do that, I kind of get the leaning of the intent. That
they're saying, look, you went out of your way to create a document that actually disinherits your children. A document treating your kids equally is more natural, normal, but this is obviously obviously you're showing your intent here. And they followed that. And I like that they did that, I guess, if that's truly what he wished. So that's the first thing. Don't follow this case. Now, what happens? Let's talk about the consequences a little bit of not funding trusts. Well, from a revocable trust standpoint, the assets would likely go to probate.
Right.
Now, if you have a pour-over will built in, then the asset would actually get poured into the trust, and the trust would distribute the assets the way you want.
After it goes through probate, though, right?
Right. Even with a pour-over will, it's a safety net. It's nice to have it, and it would get it into the trust, but it would still go to probate. And, of course, if you haven't funded the trust in general, it also just goes to probate. All right. So what about not funding an irrevocable trust, right? So let me back up 1 minute. Back to the revocable trust. Not only could you possibly, if it's not funded, go to probate, you could possibly avoid the entire estate plan, right? I mean, if all these assets are owned jointly, then, everything would just go to the surviving joint owner or spouse, more likely than not, and you waste your exemption. You waste the ability to shelter any assets on the first death through the use of the trust, and likely could possibly be increasing the estate tax liability both at the federal and the state level when the survivor dies. So that's some big consequences.
Sure. Could be very big.
And if you forget to plan again, then the way in which you leave the assets to the family might also be adversely impacted. So bad things happen when you don't fund a trust.
Yeah, especially if you've gone through the whole process of creating your trust plan, and then you're just right there, right at the
you're knocking on the door.
The end zone,
the
whatever
end
that
zone.
Line is called.
The goal line, Susan.
The goal line. You're right at the goal line.
End zone. Oh, my gosh. And so now let's switch gears and say, well, what if we don't fund an irrevocable trust? The client comes in and we've got these irrevocable trusts that we put together, and one for a husband, one for wife, and all of a sudden, one of you gets sick and go in the nursing home. Well, you haven't died yet because we're talking about irrevocable trusts.
Right.
Are there consequences? Yeah, probably more so than normal. Yeah, not only if you did die would it avoid probate, and possibly, it would go to probate if you didn't fund it. It would possibly waste your exemption if you didn't fund it. All that I still get. But more importantly, with an irrev trust, if you don't fund it, you never start that 5-year waiting period running.
And then you're forced to do last-minute planning tips as if you've never done your planning.
Yeah, and that's the key. You're faced with, not only you're faced with last minute, you're right. You're knocking on the other goal line door saying, I'm going in a nursing home, and you come in, and I've had this happen. Clients will come in and they'll say, either I've done my planning, and my mom's going to the nursing home, I'm all set, what do I do? And I look at their trust. They said, but we know that the planning, and they hand me the trust, and it's either A, revocable, and I tell them, well, you did planning, but more of estate planning than you did nursing home planning, so this didn't start the 5-year clock at all. Or B, they come in and you say, oh, this is irrevocable, at least that's a good sign. Now what's in it? And they look at you and they go, what do you mean what's in it? Oh, boy. So if you never transferred it, then those assets are also at risk. So, folks, really get this guide, learn how, if you did make that mistake, how you can fix it and protect these assets last minute. 866-848-5699 or legalexchangeshow.com to get the guide. it's the last chance as we're headed to the end of the month.
Thanks, Todd. Folks, you've been listening to Todd Lutsky, a partner with the law firm of Cushing and Dolan. I'm Susan Powers, a financial advisor with the Armstrong Advisory Group, and we'll be answering your listener questions when we return to the Legal Exchange with Todd Lutsky.
You've worked hard to achieve wealth and prosperity. Don't let an unexpected nursing home stay take it all away. According to Genworth, the average monthly cost for a private room in New England could increase by up to 25% by 2030. If you or a loved one might need nursing home care in the near future, and you're not prepared to handle these kinds of costs, you need to call the experts at Cushing & Dolan and get their new guide called Long-Term Care Planning for Procrastinators. In it, you'll learn strategies that can help you protect your assets that you've worked a lifetime to attain. Don't put off today what you might really need to do tomorrow. Call Cushing & Dolan right now at 866-848-5699 and get your free guide called Long-Term Care Planning for Procrastinators. That's 866-848-5699. Or you can request it online by visiting LegalExchangeShow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing and Armstrong do not endorse each other and are not affiliated. The United States Virgin Islands are St. Croix, St. Thomas, and St. John, and they are the perfect place for your next vacation. From the moment you arrive, you'll find yourself falling naturally in rhythm with the heartbeat of the islands. Because with perfect weather and year-round temperatures of 75 degrees, relaxation is at its finest. Enjoy their spectacular beaches, world-famous cuisine, golf, tennis, and a wide variety of water sports. The U.S. Virgin Islands is one of the most popular vacation spots in the Caribbean, so head to visitusvi.com and explore their wide variety of travel packages today. There's no money to exchange, no passport required, and best of all, no more domestic travel restrictions to enter. Paradise awaits you. Go to visitusvi.com for more information and to book your trip today. Come to America's Caribbean paradise. Visit usvi.com. That's visitusvi.com.
For 40 years, Cancer Support Community has been a relentless ally for anyone impacted by cancer, with free services provided online and in person, with their newest location in Massachusetts. Connect with Cancer Support Community Massachusetts for free emotional support, educational resources, patient navigation, financial counseling, and more. 617-797-3391. CancerSupportMass.org. CancerSupportMass.org.
Veterans benefits just got a whole lot better. Whether you're about to leave the service or you've been out for decades, the PACT Act gives eligibility for VA benefits to thousands of veterans. The PACT Act is a new law that expands benefits for veterans exposed to burn pits, Agent Orange, and other toxic substances. To learn more, visit va.gov/PACT or call 1-800-MY-VA-411. If you or a loved one served this country, it's time to get the benefits you deserve.
An extended nursing home stay could deplete your savings in months if you're not prepared. Learn about the steps you need to take to protect yourself, your family, and your assets from these high costs. Get Cushing & Dolan's new guide called Long-Term Care Planning for Procrastinators. Call 866-848-5699. That's 866-848-5699. Or you can request the guide online by visiting LegalExchangeShow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing & Dolan and Armstrong Advisory do not endorse each other and are not affiliated. You're listening to The Legal Exchange, and it's time for Ask Todd, the segment where Todd will answer your questions about anything and everything that's included in the estate planning process. Once again, here's Todd Lutsky and Susan Powers.
Welcome back, Todd. We have a few questions from listeners. First question comes from Ken in Rockland, Mass. And Ken writes, my father is ill and needs to set up a trust as soon as possible. We would like to put his Massachusetts summer home and some land into the trust, as well as his home in Florida. He is a Florida resident. Does he need a trust in Florida or Massachusetts? Could he quitclaim the deed to me and then I can put it in a trust? Will that keep the step up in cost basis?
Oh, there's a lot to unpack.
There is a lot to unpack. So dad is ill.
Well,
needs to do something.
So again, I think the first part of this is the ill part, and then the second part is Florida resident, right? So if he's ill, the first question we should be asking is how ill? I mean, are you nursing home bound in the next 5 years ill?
No. So I did paraphrase because it was a very long question that came through. Yeah. His quote was time is not on his side, so I assume he's terminally ill.
Oh, okay. So if he's more terminally ill, then we're really not worried so much about the nursing home. It doesn't sound like.
Right.
We're more worried about, hey, probate. In this case, if
yes.
He's got two houses, so he's got one here in Massachusetts and one in Florida.
And it sounds like maybe some land here in Massachusetts as well.
And some land. So the real estate in Massachusetts, of course, if he dies a resident of Florida, they're still going to tax the Mass property. And again, all this added up could be less than $1 million. I don't know. But at the end of the day, you just don't want to be probating in two states. Mm-hmm. And even if you died a resident of Florida, you're going to have to probate your property in Florida. And you're going to have to probate your property in Mass. So you're going to have double the pleasure of probating. So, yes, I think a trust is the way to go. Mm-hmm. Based on his health, I think a revocable trust is probably the way to go.
Would probably accomplish all his objectives.
Those objectives then would be what? Avoiding probate for sure in both states and getting a step up in basis on the property by funding the trust and dying owning it. Mm-hmm. So thereby we would eliminate all of the built-in gain for capital gains tax purposes. Also, since he's a Florida resident, we don't have to worry about death tax in Florida.
Right.
And in Massachusetts, he might not have to worry about it either, depending on the size of the estate. But again, remember, the real estate in Mass, even if you're a non-resident, unless that real estate is owned in an LLC, they are going to tax you in Massachusetts on your Massachusetts property as a percentage of the entire estate. So the denominator will be the whole estate. The numerator will be your Mass property. Get a quotient when you divide the two, and it's that percentage that you multiply against the value of the whole estate and find out what the tax is. Or you calculate the tax based on the value of the whole estate.
Sure.
And then hit it at that percentage. So I think the revocable trust will accommodate all of that and get the step up and provide bloodline distribution for his family.
If he has a power of attorney for his dad, will that allow him to do this on his behalf?
Have to really read that power of attorney.
May or may not.
Yeah, you really have to check the power of attorney, make sure it allows specifically for the creation of trusts and specifically for the funding of trusts.
Okay.
But his last question is, can you transfer it to the son and the son puts it in a trust and get a step? No. Don't do that. There is no benefit in transferring it to the son first and then into the trust. So, folks, this is someone who did wait a long time to do their planning, and they might luck out getting it done. But if you find that you didn't get your planning done and you're faced with going into a nursing home, don't write the check. It's $15,000 a month. There's a way to protect assets last minute. Convert countable assets to non-countable assets. Homes, rental properties, vacation homes, investment portfolios. Learn how to do it. It's the last chance to get the guide. We're at the end of the month. Long-term care planning for procrastinators, folks. 866-848-5699 or legalexchangeshow.com. Again, that number to get the guide is 866-848-5699 or legalexchangeshow.com. RealestateExchangeShow.com.
Todd, our last question comes from Barbara in Carver, Mass. And Barbara writes, my husband and I created 2 irrevocable trusts 7 years ago with your firm.
Oh, good.
We still have close to $600,000 in IRAs split equally between the two of us. My husband has been failing and it is likely he will need to go into the nursing home. Will we be able to save our IRA accounts? We only receive Social Security and rely on the IRAs each year for income.
So, folks, this is another example of people who do planning, good, and still can't protect every penny. And that's not bad. In advance, right. In advance. You can't protect every penny in advance. And again, I always tell people, pigs eat, hogs get slaughtered. I get that expression. So that's because I grew up in Ohio. We have farms. Mm-hmm. And so now, can we protect it last minute? Well, in this case, the stuff in the trust is protected. The IRAs likely have designated beneficiaries, so if they died, it would go to the beneficiary. But in this case, they're not worried about the dying part so much as they are saying he's faced with nursing home care before he passes.
Right.
So let's split the 600, 300 each. The 300 that is in her IRA, so she's the one healthy, in her IRA, is at risk. The 300 that's in his IRA is at risk. Mm-hmm. She's allowed to keep about $135,000 of assets. It's always indexed every year. It's right around that number. Okay, well then we would look at, $130,000 of her IRA and we'd leave that alone. Let it just sit there. Let it be invested however it's invested. The other portion of her IRA, inside the IRA, we would purchase a Medicaid annuity. Now, these are special annuities, folks, not annuities that you run out and buy on your own. I'm not a financial advisor, but I am telling you that they are special annuities designed to protect assets from the nursing home. We're not worried necessarily about your return on investment here. You just want to save it.
This is last minute to save those assets from the nursing home.
That's right.
And you'd never buy it before you're in.
No, you would never buy these before you're in a nursing home. And if someone's selling them to you, they're giving you misinformation. So at this point, we buy that annuity and we convert a portion, the amount over $135,000 of her IRA, to an income stream. That's what this annuity would do. Mm-hmm. And it would guarantee her the right to get all that money back over a period of her lifetime. Life expectancy, you go to a life expectancy table and you find that number and you buy that annuity in that portfolio or in that IRA. So the income tax hit's not bad. She might be, the amount that's coming out of that annuity to her might be equal to or not really much more than her required minimum distribution anyway. So who cares? Okay, Todd, that's great, but there's still $300,000 sitting in his IRA. What are we going to do with that? Well, those are always problem child assets, if you will. So in this case, the only way to protect that, because he is only allowed $2,000. So if he's only allowed $2,000, we need to liquidate his IRA, transfer the money out to the spouse, which is, by the way, a permissible transfer. So you're allowed to transfer that to the spouse. And these are also things explained in the guide, how you make these transfers. So you can make that transfer to the spouse. Then, because you pulled the money out of the IRA, yes, there's going to be an income tax hit.
Right.
So that $300,000 is going to be ordinary income for them that year. So they're going to lose on $300,000, I don't know, 30%.
Yeah.
Maybe. So, that's $90,000. But you know what? At $15,000 a month, you're going to lose that pretty quickly, depending on how long he stays in the nursing home.
You mean if they were private paying?
If they were private paying. Mm-hmm. So now we give it to her. She buys another special Medicaid annuity that we just talked about, converting it to an income stream, and he's immediately eligible for Medicaid. So now we saved assets for the healthy spouse, so the healthy spouse isn't bankrupt, and we got on Medicaid. So, folks, if you're stuck last minute, please don't, when I say don't write the check, don't bankrupt your wife. Don't bankrupt your spouse.
Yep.
Get the guide, 866-848-5699 or LegalExchangeShow.com.
Thanks, Todd. Folks, if you have a question you would like to ask Todd, visit his website, legalexchangeshow.com, and click on the Ask Todd tab. Maybe we'll be able to read your question on the air, and hopefully his answer will stop you from being his next real-life story. We'll be back in just a few minutes. You've been listening to Todd Lutsky from the law firm of Cushing & Dolan. I'm Susan Powers from the Armstrong Advisory Group.
You've worked hard to achieve wealth and prosperity. Don't let an unexpected nursing home stay take it all away. According to Genworth, the average monthly cost for a private room in New England could increase by up to 25% by 2030. If you or a loved one might need nursing home care in the near future, and you're not prepared to handle these kinds of costs, you need to call the experts at Cushing & Dolan and get their new guide called Long-Term Care Planning for Procrastinators. In it, you'll learn strategies that can help you protect your assets that you've worked a lifetime to attain. Don't put off today what you might really need to do tomorrow. Call Cushing & Dolan right now at 866-848-5699 and get your free guide called Long-Term Care Planning for Procrastinators. That's 866-848-5699. Or you can request it online by visiting legalexchangeshow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing and Armstrong do not endorse each other and are not affiliated.
Veterans benefits just got a whole lot better. Whether you're about to leave the service or you've been out for decades, the PACT Act gives eligibility for VA benefits to thousands of veterans. The PACT Act is a new law that expands benefits for veterans exposed to burn pits, Agent Orange, and other toxic substances. To learn more, visit va.gov/PACT or call 1-800-MY-VA-411. If you or a loved one served this country, it's time to get the benefits you deserve.
An extended nursing home stay could deplete your savings in months if you're not prepared. Learn about the steps you need to take to protect yourself, your family, and your assets from these high costs. Get Cushing & Dolan's new guide called Long-Term Care Planning for Procrastinators. Call 866-848-5699. That's 866-848-5699. Or you can request the guide online by visiting legalexchangeshow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing & Dolan and Armstrong Advisory do not endorse each other and are not affiliated. The United States Virgin Islands are St. Croix, St. Thomas, and St. John, and they are the perfect place for your next vacation. From the moment you arrive, you'll find yourself falling naturally in rhythm with the heartbeat of the islands. Because with perfect weather and year-round temperatures of 75 degrees, relaxation is at its finest. Enjoy their spectacular beaches, world-famous cuisine, golf, tennis, and a wide variety of water sports. The U.S. Virgin Islands is one of the most popular vacation spots in the Caribbean. So head to visitusvi.com and explore their wide variety of travel packages today. There's no money to exchange, no passport required, and best of all, no more domestic travel restrictions to enter. Paradise awaits you. Go to visitusvi.com for more information and to book your trip today. Come to America's Caribbean paradise. Visit usvi.com. That's visitusvi.com. You're tuned to The Legal Exchange with Todd Lutsky. If you or a loved one needs a nursing home stay, call Todd right now at 866-848-5699 and let him make sure your assets are protected. That's 866-848-5699 or visit him online at legalexchangeshow.com.
Welcome back into the Legal Exchange with Todd Lutsky. I'm Susan Powers, a financial advisor with the Armstrong Advisory Group, and I'm joined, of course, by Todd Lutsky, a partner with the law firm of Cushing & Dolan with a master's in taxation. Todd, I know you have a couple of updates for us about pooled trust, but before we jump into that, I just want to refresh folks' minds about taxes, because we're there. Everyone's starting to get their tax forms in the mail. So whether it is folks, this is their first year doing taxes for their irrevocable trust, if they created them last year,
Sure.
or just as a refresher for folks who have their irrevocable trust for a while now, kind of give them the points and tips that are important for them to remember when it comes to filing taxes,
Tax prep.
irrevocable trust, and maybe it'll be a surprise that they have to file taxes.
Yeah, it shouldn't be if they did planning with us.
Right, but there are a lot of people
know
out there that didn't
didn't.
with you.
So for all you folks that have went down the planning road, Susan, you are right that it is, we're getting very close. February is February to April. You are, if you're an accountant, you're up to your eyeballs in alligators doing taxes. And so you need to be thinking about yours. Usually I think by the end of January, all the 1099s have to be issued by the institutions to you, telling you what interest, dividends, gains you had incurred in your portfolio.
It's February now, just so you know.
Yeah, well,
for investment accounts, yeah.
Oh.
All the big custodians
they
have
push
an
it off
extension
till
for
February?
Yeah.
Okay, don't panic. It's February.
All the mutual fund companies are always late reporting their stuff, so they wait until the end of February.
Well, thank you for that update, Susan. I didn't realize that, but
I'm sure to educate you.
You will get these, nevertheless.
Eventually they will come.
At some point, you will get these. And I think it's important to remind you that if you worked with Cushing & Dolan, you know this. If you haven't, you may or may not know this. If you've done a trust and all you put in there, it's an irrevocable trust I'm talking about. Revocable trust, you don't need to file any separate income tax returns for. So let's make that distinction right now. You don't even need to file.
That's because it's under your Social Security number.
Right.
And it just goes on your regular.
Right on your regular tax return. It is a grantor trust like the irrevocable trust is, but it's one that doesn't require a filing.
A separate filing. You got to file your taxes.
You file your own personal, but not a separate trust return.
Yes.
Whereas with the irrevocable Medicaid trust that we do, they are also grantor trusts, but you need to file. When? You need to file if the trust has income, and I believe it's income greater than either $100 or $300. There's a limit right on there. 600 on the outside. It's one of those numbers. Not much is my point. You pretty much need to file. But you only need to file, like you might be saying, well, Todd, what if we only put our vacation home in the trust and a piece of our primary residence, and neither of which are generating income? Well, you don't need to file. In fact, you wouldn't have even got a tax ID number, so the IRS wouldn't even know that this entity exists.
Right.
And we're not being secretive. That's perfectly okay. But if you put an investment portfolio in there, or you have rental property that's receiving rental income in the trust, well, then you need to file. And if you file something called a Form 1041. And in the upper left-hand corner, you check a box marked Grantor Trust. Your accountant should know this. And then what that means is there'll be zeros on the return, and you'll kick out a letter that says, hey, donor, creator of the trust, here's what your trust earned. Interest, dividends, gains. And whether you actually physically take the money or not, folks, does not matter. So don't think, oh my gosh, I didn't take any money out of the trust. I just reinvested it. Doesn't matter. It's still going to be reported on your personal income tax return, which is great news because you're at a lower rate guaranteed than the trust would be if the trust had to pay the tax. So you pay the tax just like you would at your normal ordinary rate. These trusts are income tax neutral, folks. You're not going to be harmed by it at all. So file, but good news on that front. Now, since we are at the end of the show almost, and it's the last chance ever for the month, I'm just going to tell you one more time about protecting assets. That's for folks that did the trusts, you got to file the tax returns. For folks that did the trust and there's still assets outside the trust, or for folks who haven't done a trust at all and find themselves faced with nursing home care, this guide will help you protect assets last minute. Really can educate you on doing that. Long-term care planning for procrastinators. Can learn how to protect and convert countable to non-countable assets. 866-848-5699 or legalexchangeshow.com, and understand even how to transfer assets, permissible transfers that do exist last minute. 866-848-5699 or legalexchangeshow.com. We are at the end of the month.
We sure are.
Last chance, folks.
The dots. Yep. Okay. Pooled trust. You have an update for us on the
legislative front.
Yeah.
So legislatively, folks, you have to understand a couple of things that we've been fighting, and I want to bring you up to speed as to what we've got on the legislative agenda. Estate recovery, right? They're now trying to figure out a new law, and basically it's to help alleviate problem. Like, the bill is going to make changes to parts of the statute that establish the estate recovery rules to make the statute less burdensome and more equitable on low-income families. This is really the only benefit program that the benefits need to be repaid by the deceased family's spouse or the deceased family in general.
That's what estate recovery is?
Yeah, estate recovery means if you get on Medicaid but you have assets in your probate estate when you die, they are going to be able to get repaid.
Okay.
Now remember, folks, don't worry if you did it in an irrevocable trust. Those are not probate assets.
Right.
So there is no payback if you're on Medicaid and the assets are in the irrevocable trust. So please distinguish the two. But if for some reason the asset is still in your name and we did this last-minute planning that the guide talks about, well, the house might be safe and you can get on Medicaid, but they might put a lien on the house at a Medicaid rate, which is 50% less than private pay rate, and that house would be needed to be used to pay back the state. That's estate recovery.
Right.
But again, only on probate assets. They're thinking of making some changes to that. I'm not going to report on the changes because it's in process, and I want to only tell you what the final changes
but they're
end up
looking
being.
at it.
Yeah, so I think that's exciting. Then equitable treatment of life estates in how to calculate a remainder interest in a life estate. Folks, we've spoken on it before. In 2019, they came out with a new statute, not a new statute, Medicaid came out with a new regulation that says, here's how you calculate your life estates. To keep it simple for you, life estates and remainder interests are calculated based on an interest rate generally, the applicable federal rate, and an IRS table using your age and your life expectancy.
Right.
And you use those numbers to calculate what percentage is allocated to the life estate and what percentage of the proceeds would be allocated to the remainderman. That's how the IRS tells us to do it. Well, Mass Health decided to have us use this Social Security Palms table for life estate calculations. They're very different.
Yeah.
And so the calculation is off, and now we don't know which one to use for income tax reporting when you sell your property if there's a life estate on it, or for Mass Health purposes. So it's confusing everybody. They're working on legislation to get rid of that and go back to doing it the way the IRS tells us to do it.
Perfect.
And lastly, and perhaps most importantly, pooled trusts. I don't know if you're aware of it, but Governor Baker, on the way out of his office, vetoed legislation that allowed pooled trusts to remain in existence.
Oh. Huh.
Yeah, so that was a little disappointing for me and probably for everybody. And now that legislation is back on the table. They're going to either, they're going to give it to the new governor saying, look, let's get this on the table. Let's make pooled trusts last forever. They're great stuff to do last minute. Folks, in a nutshell, we don't have a lot of time. It's a way of taking assets last minute, like the guide indicates, and this is all in our guide, and you can transfer them to a pooled trust, avoid the 5-year waiting period, get on Medicaid. Yes, there's a payback provision, but ultimately you can get on Medicaid. That's in the guide, folks. All about pooled trusts, how to do this. 866-848-5699 or legalexchangeshow.com. That's how you get it. It is the last chance. We are at the end of the month, Susan.
So pool trusts have not been put to
Bed.
death or bed
Yet.
Okay, keep us posted on that. Todd Lutsky from the law firm of Cushing and Dolan, thank you so much.
Thank you, Susan. It's always a pleasure.
I'm Susan Powers, a financial advisor with the Armstrong Advisory Group. We thank you for joining us today, and we'll be back again next week on The Legal Exchange with Todd Lutsky.
You've worked hard to achieve wealth and prosperity. Don't let an unexpected nursing home stay take it all away. According to Genworth, the average monthly cost for a private room in New England could increase by up to 25% by 2030. If you or a loved one might need nursing home care in the near future, and you're not prepared to handle these kinds of costs, you need to call the experts at Cushing and Dolan and get their new guide called Long-Term Care Planning for Procrastinators. In it, you'll learn strategies that can help you protect your assets that you've worked a lifetime to attain. Don't put off today what you might really need to do tomorrow. Call Cushing and Dolan right now at 866-848-5699 and get your free guide called Long-Term Care Planning for Procrastinators. That's 866-848-5699. Or you can request it online by visiting LegalExchangeShow.com. The United States Virgin Islands are St. Croix, St. Thomas, and St. John, and they are the perfect place for your next vacation. From the moment you arrive, you'll find yourself falling naturally in rhythm with the heartbeat of the islands. Because with perfect weather and year-round temperatures of 75 degrees, relaxation is at its finest. Enjoy their spectacular beaches, world-famous cuisine, golf, tennis, and a wide variety of water sports. The U.S. Virgin Islands is one of the most popular vacation spots in the Caribbean. So head to visitusvi.com and explore their wide variety of travel packages today. There's no money to exchange, no passport required, and best of all, no more domestic travel restrictions to enter. Paradise awaits you. Go to visitusvi.com for more information and to book your trip today. Come to America's Caribbean paradise. Visit usvi.com. That's visitusvi.com.
Veterans benefits just got a whole lot better. Whether you're about to leave the service or you've been out for decades, the PACT Act gives eligibility for VA benefits to thousands of veterans. The PACT Act is a new law that expands benefits for veterans exposed to burn pits, Agent Orange, and other toxic substances. To learn more, visit va.gov/PACT or call 1-800-MY-VA-411. If you or a loved one served this country, it's time to get the benefits you deserve.
An extended nursing home stay could deplete your savings in months if you're not prepared. Learn about the steps you need to take to protect yourself, your family, and your assets from these high costs. Get Cushing and Dolan's new guide called Long-Term Care Planning for Procrastinators. Call 866-848-5699. That's 866-848-5699. Or you can request the guide online by visiting LegalExchangeShow.com. The proceeding was paid for and the views expressed are solely those of Cushing and Dolan. Cushing and Dolan and/or Armstrong Advisory may contact you offering legal or investment services. Cushing and Dolan and Armstrong Advisory do not endorse each other and are not affiliated.